A standard essential patent is a patent that, as the name suggests, is intended to protect an industry standard. Examples include USB, Wi-Fi, and JPEG. Today we'll get some insight into how standard essential patents are created, how they're licensed, and some of the unusual legal issues that they raise. Hello, and welcome to Talks on Law. I'm Joel Cohen. Today we're joined remotely by a patent expert, Raghav Bajaj of the law firm Haynes and Boone. Raghav, welcome to Talks on Law.
Thank you, Joel. Very happy to be here.
Today we're talking about standard essential patents. What about a quick definition for everyone?
So a standard essential patent, to understand that, you need to know what a standard is. So standards are all around us. Your cell phone has LTE or 5G. Those are both standards. Your computer has Wi-Fi. That's a standard. You go to Netflix or Hulu. That has video covered by standards. So standards are everywhere. And standard essential patents are patents that are required when you're implementing a standard.
Is this enabling people to harmonize their technology, or does it allow people to have access to these patents because they're necessary?
The standards are used so that, like I said, there's interoperability. So when I have a Wi-Fi router from whatever manufacturer, it doesn't matter what other phone or PC or Mac that I buy, I can connect to that router, and those companies have agreed to follow the standard. And as part of following the standard, they have to use some patents, some technologies developed by companies all around the world that have agreed to license their patents as part of a standard. So there are thousands of standard essential patents in any given technology.
How does a regular patent become a standard patent?
Yeah, so I'll step back a little bit. When companies get together to form a standard, they meet together with a bunch of industry participants and they define a document that says this is how the standard is going to work in various different aspects. And when they contribute their technological developments, they say, I'm contributing this technological development and it is covered by one of my patents. So if I contribute a development about how two Wi-Fi devices are communicating with each other and I say that's covered by my patent, if the standard incorporates that method of communicating between the two Wi-Fi devices, my patent is now a standard essential patent.
So if these are standards, do the patent holders have all the power? Are you kind of over a barrel here and you have to accept whatever terms they offer?
They have some power because they have the patents themselves, but typically when they designate a patent as essential to a standard, they also engage in an obligation with the standard setting organization to license the patent on fair, reasonable, and non-discriminatory terms. And that's very important in the competitive sense that they can't charge different implementers different rates that are discriminatory. So I'm not paying more on a per device basis simply because I sell more devices. Now, the definition of what a FRAND rate is not standard, and so sometimes there is litigation about what a FRAND rate should be for a particular aspect of technology, and FRAND litigation has been increasing, but generally companies try to work this out in a business negotiation before going to the courts.
Another interesting aspect of standard essential patents are patents that claim to be part of the standard but may not be. What's going on there?
That's called over-declaration, and it's exactly what you said. A patent is declared as essential to the standard, but in reality, practicing the patent is not needed to implement the standard. And that can occur for a couple of different reasons. When a company contributes a technology to a standard, they identify that they have a patent application on that aspect of the technology. But as the patent application goes through the patent office, whether it's in the US or in Europe, that patent application, the claims get modified, and at the end of the day, the standard may no longer read on what gets granted at the patent office. So that patent has been over-declared. Another reason is that a patent might be granted, but ultimately be found to be invalid. But it's still part of the patent pool, or it's still part of the standard, and companies are paying for that invalid patent. So those are two aspects of over-declaration. Another aspect is that there's no independent method of determining essentiality, of determining whether a patent is essential to a standard. So a company can say that their patent is essential, but unless the licensee looks into whether that patent is actually necessary for the standard, you're kind of at the patent owner's word.
In the world of standard essential patents, the patent pools have become more and more common. Why do you think that is?
So as the technologies that we work with and that we experience on a day-to-day basis become more complicated, there are more participants in the development of the standard. So the standards have become more complicated, and as a result, there are more patents that are dedicated to or deemed essential to the standard. So whereas in prior standards, you may have had 100 patents and maybe 5 or 10 patent owners, now some patent pools include 10,000 patents or more. And so trying to negotiate a license that covers 10,000 patents with each individual owner is really difficult. So patent pools streamline that by making it much easier for a potential implementer to license a pool of standard essential patents and implement that technology.
If I'm needing to implement a standard, there may be 10,000 patents that are being paid out in my license?
That's exactly right. Some of the video standards that your phone uses or that some of the streaming providers use cover in the tens of thousands of patents in the US and around the world.
Raghav Bajaj, thank you for your time today.
Thank you, Joel. It's great talking to you.
And thank you for watching Talks on Law.